The North Carolina Court of Appeals is back in session.
Thank you. We'll move on to our second case this afternoon, Vlassis versus Adient.
May it please the court, my name is Mark Sigmund and I represent the plaintiff appellant Cameron Vlassis.
Would you like to reserve rebuttal time?
7 minutes, please.
Okay. Judge Griffin, can you? Thank you.
The trial court below erred as a matter of law for 2 reasons, either one of which is sufficient to reverse here. First, there is specific jurisdiction in this case. And frankly, this is not actually a difficult case. Adient sold its seat new to Nissan, who then installed it in one of its most popular models, and then sold it at one of 41 Nissan dealerships in the state, directly to Nash County, right where we sit, leading directly to the accident.
I want to ask you a question first. In the briefs, you're only referring to Adient US LLC. So have you abandoned any appeal as regarding the other 7 or 8 defendants?
We have, yes.
Okay.
And that's based on the defendant's representations, that it's that entity that actually did all the stuff that matters here.
Right.
So the reason I say it's not a difficult case is because, as I mentioned, Adient manufactured a seat and sold it to Nissan. Nissan put it in one of its most popular car models and then sold it to one of its 41 dealerships directly here. The stream of commerce theory of jurisdiction is perfectly valid in this state and in every other state, but you hardly even need to rely on it in this case because that connection is so direct and so immediate. And second, Adient consented to jurisdiction here because it voluntarily chose to register to do business and designate an agent who was then served, which rendered Adient found in North Carolina and therefore subject to jurisdiction on all claims, as the North Carolina Supreme Court has recognized.
How do you respond to Adient's contention that any claim for general jurisdiction was waived by plaintiff in open court?
Well, so as we put in the briefs, we have 2 arguments. One is specific jurisdiction, and then one is consent jurisdiction. And consent jurisdiction is not general jurisdiction.
Because there's some view it as really consent to general jurisdiction.
Your Honor, I get why there's confusion because the effect of consent jurisdiction is consent to all suits, which is the same effect of general jurisdiction. But as the Supreme Court, Justice Vlassis recognized in Mallory and as other courts have recognized, they're very different things. It's a different venue. In fact, some courts will analyze consent while explicitly acknowledging that jurisdiction was waived.
Well, have you consistently argued for consent by registration jurisdiction?
We have, yes. I mean, okay. as soon as the Adient registered, we did. Mm-hmm. But I do want to, I'm happy to address any questions the court have. And again, this court can and should reverse on either basis. But I'm going to start with specific jurisdiction. And as I mentioned, I do think it's an easy case. And I don't say that cavalierly or glibly. In fact, I rarely say that. But I say that here for a good reason. And that is that Adient's argument on appeal is very simple and it's very wrong. What Adient argues is that a first-tier component supplier, like itself, is not subject to jurisdiction unless it sells directly into North Carolina. That if it uses a distributor, like Adient here used Nissan, that it cannot be subject to jurisdiction. The problem with that argument is that there's just no support for it. It's utterly baseless. There's not a single North Carolina case that has that as the rule. There's not a single federal case that has that as the rule. There's no other case that has that as the rule. And of course, there's tons of cases to the contrary. And we cited a bunch. We cited the Bush case. That was the washing machine from Sweden to a New York distributor to North Carolina. We cited the Cox case. That was a pressure washer case. Same thing. The machine made itself in North Carolina via a distributor. We cited the Thurman v. Honda case. That case is literally directly on point. It's a component seat that was made and installed in a Honda in another state, then brought into the forum state. That court had absolutely no problem concluding that there was specific jurisdiction there.
Of course, that case doesn't have any precedential value in North Carolina.
That's correct. It's a federal case in Missouri, and we cited it just because it's literally directly on point. But it might not have precedential value, but that court, like I said, had no difficulty reaching that conclusion. It was not a hard decision. We also cited the Lorenzen case versus Toshiba. That was a battery installed in a laptop outside of the forum state, brought into the forum state. Again, that's just persuasive. To Rhode Island, same thing. That court had no difficulty reaching that conclusion We cited both of those cases. They failed to even address it. And then last week, we cited 2 more cases. We cited the case from Oregon, where there's a wheelchair battery charger installed in the wheelchair outside of the state, and then the wheelchair manufacturer sells the completed wheelchair in the form state. No problem concluding there that there was jurisdiction. And then we cited the Kia case, Kia and the seatbelt, same thing. The seatbelt is installed in the Kia out of the state, and the Alabama Supreme Court says, of course they're subject to jurisdiction here.
Well, I mean, but even the U.S. Supreme Court can't agree on stream of commerce jurisdiction, can it?
Well, yeah, I mean, there's certain complexities, and those complexities might exist in other cases where the stream matters. But like I said, I mean, we're literally, the only way we can lose here is if you adopt their argument, which they admit is their argument, that if you use any distributor at all, you lose. You've got to sell directly into the state.
Well, okay, so if you look at stream of commerce plus, can you show stream of commerce plus?
I don't think we have to, but certainly, I mean, we have all the other contexts here that existed, all the ones that we mentioned, from the fact that Adient agreed to indemnify a Nissan wherever its cars might be sold. And there's 41,000 of them here with that very seat. Adient agreed to indemnify them. So obviously Adient knew or should have known that cars were being, that this exact car was being sold in North Carolina because it agreed to indemnify them here. I mean, are we supposed to believe that Adient agreed to indemnify Nissan and had no idea that where it actually might be agreeing to indemnify, plus all the other contacts that we mentioned. So
was there something, didn't Adient agree, didn't they provide repair parts to North Carolina?
They did, and they provided thousands of instances of that, and one of which was for the exact make and model here, a 2017 Nissan Altima. So they were actually, of course, aware that that Altimas were here. And to be clear, they never claimed, of course they wouldn't, that they're unaware that Nissan Altimas are being sold in North Carolina. I parked behind that building out there, and I counted 3 just on the way in. I mean, it's a popular model, and so I don't think they can claim that. They haven't actually claimed it, and I respect that. It wouldn't make sense.
Is there any argument that North Carolina long arm statute does not confer personal jurisdiction here? I mean, distinct from the due process argument, just the long arm statute itself.
No, not at all. I mean, the only argument they even make is on a footnote. And, we addressed that. I mean, the statute itself is obviously very broad, and there's lots of cases where this court, even cases where this court finds that the due process has not been satisfied, where the court finds that the long arm is satisfied. And so, and on its face, I mean, it is. It says any action claiming injury to a person within the state arising out of an act or omission outside the state, provided that in addition, I mean, I don't want to keep reading, but.
No, go ahead, please.
Provided that in addition that at or about the time of the injury, either products, materials, or things processed, serviced, or manufactured by the defendants were used or consumed within the state in the ordinary course of trade. I mean, so that would apply. And then, of course, the previous section, if the defendant, quote, is engaged in substantial activity within this state, whether such activity is wholly interstate, intrastate, or otherwise. So I think that in this case, this is one of the, it's pretty much always happens where the due process collapses into the statutory analysis. I think that's where we are. And of course, there's the principle that we have to construe our long arm to reach the reaches of due process. And so if there were any ambiguity here or any issue, I don't think there is, it collapses into due process analysis. Anyway.
So are you saying we don't have to address the long arm statute at all?
The court does, of course. The court has to say it satisfies the statute and then you do the due process. But the court, they say that when the due process, or when the statute is satisfied, that collapses into the due process analysis. And so, in effect, you end up doing one analysis. If you look at all the recent cases, I mean, there's hardly ever a real deep dive into the statute because that part's satisfied, and then you look at the due process analysis. The cases we cited last week, one was the wheelchair battery, and the other one was also directly on point. It was a seatbelt in a Kia case, and that was where the Alabama Supreme Court held that it was obvious that there was jurisdiction here. One point I definitely wanted to make this morning is that, or this afternoon, is the effect of what their argument would be. Because in North Carolina, we don't have any car manufacturers based here. We also don't have any first-tier component suppliers based here. And so if their argument prevails today, then anyone in North Carolina that gets in a car wreck, if it's the seatbelt that fails or the airbag or the brakes or some component, under their theory, and they admit this by admission, that you would have to sue the car manufacturer here, Nissan, Kia, Honda, but then you got to go to California to sue the seatbelt guy, and you got to go to Florida to sue the airbag guy, and you got to go to somewhere else to sue the brake guy. And, the law doesn't require that. It's quite the contrary. And I spent countless hours in Westlaw trying to find some case out there where a state subjected its citizens to that burden. And there is none. We would be a radical outlier in this country if we were the only state that held that if you get in a wreck here, you have to sue in multiple different courts. We pointed that out in our opening brief. They have no response to that because that's true. I mean, that is a fact of the rule that they're advancing here. And that's just, unfortunately, the law doesn't require that. And I shouldn't say fortunately, it doesn't require it because it makes no sense. And this is all about, practical effects. So, without outline of the law, and also mention too, just, even the cases they cite, they cited this Mosley v. Fillmore case, and they cited it for the proposition that if the defendant doesn't sell directly, then they're not subject to jurisdiction. That, of course, wasn't right. So I read that case, and, in that case, none of their products made it into North Carolina. None of them did. And in fact, the court implied that had the distributor there actually sent products into North Carolina, then the defendant out of state would have been liable. So even the cases they cite don't even support its own proposition. So most importantly, what are the contexts here? I don't think you need anything more than the fact that 41,566 Nissan Altimas, 2013 to 18, were sold in North Carolina, new, just like here. I mean, for which Adient made more than $5 million. I mean, that's enough of a contact. But, we can pile it on. We can talk about the post-warranty service and support that Your Honor mentioned. The fact that they had contracts with a lot of suppliers here. The fact that they sent employees into North Carolina, including for sales purposes, which if you look at some of the cases, they talk about the defendant's in-state travel is particularly important when it's for purposes of sales. And of course, again, that Adient agreed to defend here. So,
Does Adient provide seats or seat part components or for other vehicles or other manufacturers besides Nissan?
Yeah, my understanding, by omission and in the record, 1/3 of all seats in the entire world are Adient seats. I have not seen a list of exactly which makes and models, but yeah, the record is undisputed that tons of other makes and tons of other models. And there's some courts will, get into an exercise about what's the relevant make and model or what's the relevant product. I don't even think this court needs to worry about that because again, this is not a hard case. So this might be hard if it was the seated issue was only 10 of them here. But this court can limit its analysis to just not only this, just front passenger seats for 2013 to 2018 Nissan Altimas. That's the 41,000 number. That doesn't even include the driver's seats for those Altimas or other parts. And so just the one seat, that's all you need. That and $5 million, plenty of context. But like I said, if the court wants to just lard it up with mentioning every other contact, the court can do that, and I think the result is the same.
Do you think that would satisfy Stream of Commerce Plus?
Oh, definitely, yes. I'm not sure this would be the case to decide whether that applies, but if I were the judge, I'd probably just say even if it does apply, it's satisfied here.
Well, talking about the judge, the trial court made findings of fact regarding Adient's direct efforts to serve the North Carolina market. Do you think that the Adient's indirect efforts are relevant as well?
What is your, I apologize, when you say indirect, are you talking about like the sending salespeople here and the warranty?
Well, you tell me. What would be indirect efforts?
Well, my position is that all of these things are relevant, but that there's so many of them, and it's such not a close case that the court can only look at, I guess, what you would call the most direct contact, which is the 41,000 seats plus, and the $5 million they get. Those are clearly direct contacts. But I think all the other ones are, whether you call it indirect or direct, they're like I put in the brief, sort of piling on. But I wouldn't call any of them indirect contacts. I mean, again, the stream of commerce theory is a valid one, but this is a first-tier component supplier. This isn't some guy like in the Cambridge case where they cite, or it's not like the other cases where they cite. Most recently I'm forgetting the Bartlett case where the helicopter case, like that's totally different. They cite Bartlett. I mean, in Bartlett, the helicopter engine is sold in Europe to a European company who manufactures the helicopter in Europe, who then sells the helicopter for the first time in Europe, who then sends this helicopter to Texas, where it's sold a second time, and then it makes its way to North Carolina. I get where that comes down.
Well, do you think that Bartlett looks like a stream of commerce plus case?
I don't think the court explicitly mentioned that, but you could perhaps read it into that. And if the court does, again, I think that's perfectly consistent with this case. The court ought to just say that even if Bartlett does require something along those lines without using those terms, that the context here are radically different. I mean, literally, again, helicopter engine Europe, manufactured in Europe, sold in Europe for the first time. It was the second sale, and then that was in Texas, and then it was brought over here. I mean, here we have, Nissan sells it to modern Nissan, I think it was in Hickory or wherever, and then it's here, right next door. I mean, it's direct. And finally, of course, there's a requirement in Ford that the context have to arise out of or relate to. I think that's clearly satisfied here. It's even easier than in Ford. In Ford, it's interesting, the cars there were sold in other states and then resold into the forum state, or some of the people drove them. There's sort of custom relocations. We don't even have that here. This car was first sold new right here to Nash County. One reason I cited the Thurman and the Lorenzen cases is because those are recent cases, and so they applied for it. And so both those cases did the Ford analysis in situations directly on point, and they held that there was jurisdiction here.
Is it relevant that the injured person is a Texas resident?
No. I mean, they've never argued that it's relevant. I have no reason to. I don't know why that would be relevant. I'm going to move on. I'm happy to answer any other questions here about the personal jurisdiction. The court's prerogative to do whatever it wants. I would just rule that there is personal jurisdiction here on the minimum context and leave it at that. But if the court wants to get to the consent issue, I think that clearly there is consent here as well. Now, the most important principle to remember here is that this court and the Supreme Court has held many times that we have to construe our statutes to reach the maximum reach of due process. So whatever federal due process allows, we have to read our statutes to reach that. And as the Supreme Court made clear in Mallory, which affirmed Pennsylvania Fire, creating consent jurisdiction in this situation is clearly constitutional. It's allowable. And if it's allowable, then we have to construe our statutes to reach that way. But of course, the statutes say that, most notably 57D 705 says foreign entities registered in this state have the same duties, restrictions, penalties, and liabilities as domestic LLCs, which makes sense because it's just trying to level the playing field between out-of-state guys and in-state guys.
But that's referring to corporations, am I correct?
That 57D05, that statute refers to LLCs, but it's the exact same wording as the corporation statute.
Okay.
There's no difference between any, but I tried to be crystal clear when I was referring to the corporations versus the LLCs, but it's all the same wording more or less.
So there's no explicit statement that that by registering you consent to jurisdiction.
Well, there is in the comments. Yeah, that's why we cited the official comment. A foreign corporation that obtains a certificate of authority in a state thereby agrees that it is amenable to suit in the state.
But are the comments, do they have precedential value?
They do, yeah. And we cited, first off, the court has explicitly held that they have precedential value, that they are instructive. They're not as important.
Well, instructive is not the same thing as
fair enough.
As precedent.
They're not as important as the text, but they are important to consider. So to whatever extent that the text has any ambiguity at all, then I think the comment will be incredibly powerful, which is why this court cites the comments all the time, including in a jurisdiction case that we cited. We also cited the Robinson Treatise, of course, and that's been cited, I think, 124 times by this court.
Did Robinson cite to any North Carolina case law?
I'm sorry?
Did Robinson cite to any North Carolina case law?
Gosh, I don't have it right in front of me. I read that so
I
many
think I
times.
have it around here somewhere.
It cites
find it in here.
It cites, well, yeah, of course it does. Yes. So yes is the answer. First of all, it cites the Pennsylvania Fire, and it says that making registration equal consent is perfectly constitutional, Pennsylvania Fire, and then it cites the Central Motor Lines case.
Well, there's no question about whether or not it would be, it would be constitutional. That's not the question. The question is, has North Carolina, has our legislature done that?
But yes, I understand that, and I understand that Robinson is not a judge and this court can do what it wants, but I think it's pretty telling that the preeminent state treatise in corporate law, it doesn't, that section doesn't say, well, it's a tough call, I don't know, it could be, it just says, well, obviously this statute, means that consent is, that registration is consent. That's how I read it. And so I don't see how this court could say at a minimum there's ambiguity. And if there's ambiguity, then you run into the principle that it has to reach the extent of due process. And so I think the only way you can get around it would be to say that it unambiguously says something like South Carolina does, that says registration is not consent. But we don't have that, of course. And so I think that, and I haven't even mentioned probably the most important thing, right? The Babb and the Steele cases. Those are two Supreme Court cases that explicitly recognize that registration is consent. True, those were about prior versions of the statute, but not the prior versions weren't materially different in any way. And so, that's the Supreme Court telling people that, hey, if you register out of state, you will consent to jurisdiction, which is exactly what Judge Gorsuch was talking about, Justice Gorsuch in Mallory. I mean, his whole point was that, when the corporate form arose in the 19th century, these corporations started running around wreaking havoc and then saying, hey, I'm not, you can't tag me. And all of these, North Carolina, like every other state, said, hey, if you want to come here and sell, you got to register. And if you register, you're going to consent.
Well, in Mallory, didn't the statute explicitly state that by registering, then you are consenting to jurisdiction?
It did in Mallory, yeah, we concede that, but it did not in Pennsylvania Fire, and Mallory fully affirmed Pennsylvania Fire. I would also note, for example, we cited the Georgia Supreme Court in 2020. The Georgia Supreme Court held that its statute, which is similar to ours, provided that registration was consent. And its statute was way less clear. It held that because intervening Georgia court decisions had made clear that registration was consent, that was enough. And so, my response would be that.
You got 2 minutes before your rebuttal time.
I'm not sure.
Would you like me to quit asking you questions?
No, I can try to I don't want to soliloquize here. I would just note too, one thing, there is this battle of the federal courts in my brain, the Espin case and the Ben Credito case. Mm-hmm. But if you look at the Espin case, Espin actually cites Babb and Steele, and it says, hey, these North Carolina cases that we're bound by, they say that registration is consent. That's the right result. The problem with Ben Credito is
those cases they don't seem to be really consonant with one another, in my opinion.
I agree, which is why I wrote in the brief, someone's right, someone's wrong. And you know how we know who's right? It's the one that actually addressed the arguments. I mean, Espin addressed the comments, it addressed Robinson, it addressed Babb and Steele. Apparently in Ben Credito, the problem is that no one raised any of the things that matter. I don't know why, I wasn't there. I would have argued it differently. So I just submit that Espin is simply the better
And
result.
that happens on occasion. It happens at the Court of Appeals as well. But when we publish a case, it says it's precedent. These cases aren't precedent for us. But I don't know, how persuasive they are when they don't agree.
Certainly, and neither one was published. And I get that judges are doing quick and dirty work at times. I would just submit that the short opinion that doesn't address anything, and then you've got a long one that sort of goes through the relevant arguments.
And we object to the quick and dirty work comment.
And then I would just note, of course, that we cited the Harris Teeter Business Court case, and that court reached the correct result. It read Mallory. It saw what Mallory said. They looked at the insurance statutory analog, which is just like the statute here, and said...
Is the insurance statute really exactly the same as this one?
It is, yes. And if Your Honor is confused, it's because Adient cited the wrong statute in its brief. It cited the statute that governs insurers who do not register, and that mentions jurisdictional effect. That statute wasn't even cited by the business court. Totally irrelevant. The statute that the business court analyzed is literally exactly like the one here. It says, you have to register to do business as an insurer, and then it says, I think it says same rights, duties, and liabilities. But no, that case is directly on point.
You're going into the rebuttal time. You can use it if you want.
I'm ready to sit down. I'm happy to answer any questions. Otherwise, I'll retire.
Thank you.
May it please the court, Matthew Tilley, on behalf of the defendant appellee, Adient U.S. LLC. I'm joined here by my co-counsel, Elizabeth Christie and Lisa Perunovich, both in favor of drink your bill and breathe. I want to start with the very assertion that this is an easy case and that it is clear that Adient targeted North Carolina and has sufficient contacts with North Carolina. The court found that the only involvement Adient had with the vehicle was that it took foam that it manufactured and assembled other parts purchased elsewhere in Tennessee, in Vlassis, Tennessee, and then transferred that pursuant to a sales agreement to Nissan, which incorporated it into a car also in Tennessee. The entirety of that transaction occurred in Tennessee. Adient has no assets, no factory, no business in North Carolina, a significant business in North Carolina, and is a Michigan-based company and foreign LLC. So to suggest that there are contacts with North Carolina, it goes too far. And to suggest that this case is easy to rule on in light of Ford and in light of more recent cases from this court dealing with Ford Motor Company and stream of commerce theory, it just simply misses the mark. I would commend this court to a case that has been appealed and the Supreme Court just denied review on 2 weeks ago, and that is the Bartlett case.
Do you think Bartlett's a stream of commerce plus case?
Yes, I do. Bartlett synthesizes a number of cases both before and after Ford Motor, and says that it is not enough to simply inject a product into the stream of commerce. There has to be some purposeful availment, some conduct linking the defendant, the conduct and the plaintiff's claim and the foreign state altogether, beyond simply just putting a product into the stream of commerce. Citing back to Cambridge, Judge Legre's case, Judge Tyson said that it is not enough for a defendant to merely be connected with the manufacture of a product that was inserted into the stream of commerce in order to show purposeful availment. That's all that they can show here. And in fact, that's what they say in their brief they want to show is the rule, that simply injecting a product into the stream of commerce and not limiting it or prohibiting it from going to North Carolina is enough to establish jurisdiction.
You're not making any argument that the long-arm statute here has not been satisfied, are you?
I know, Your Honor. I mean, I think our main point is that...
So you'll concede that the long-arm statute applies, it's just basically that is distinct from the due process argument.
Yes, for an act of local injury, I think it does
Okay.
make sense here, but at least as far as the long-arm statute, but it wouldn't be consistent with due process.
Right, I just want to make sure that I understood your argument.
Okay. And in order to attack us and to attack the position, plaintiffs have really set up a straw man. They've said that we say that any first-tier component supplier is insulated from jurisdiction in North Carolina no matter what they do. That the effect of our argument would be that no first-tier supplier, no car manufacturer would be subject to jurisdiction in North Carolina. Compare this case to Ford. If you look at Ford, Ford sold its products into various states through distributors, through dealers. It sold them into the actual states. And in the Ford Motor case, it sold many cars into Montana and to Minnesota. But it didn't sell to the plaintiff. And it said, well, okay, that's the line of separation. The court said, no, Ford developed a market for its products in those states. It advertised Ford cars in those states. It sold Ford cars into those states and then had a large service component to what it did, where it sold service parts and service cars in those states. Adient does none of those things.
Well, doesn't Adient provide replacement parts?
And that's one place where
Carolina?
we think the plaintiffs have gone too far with the record. So there's a master supply agreement between Adient and Nissan that says Adient will reimburse or cover the cost of warranty claims that Nissan receives. There is evidence of one time, in one instance, when Adient was directed by Nissan to drop ship a replacement part to a dealership in North Carolina. That's a unilateral act. That's not its action. That was directed by another party.
Is that different from warranty parts?
I don't, Your Honor, I think the main point, though, is that it's a relationship with Nissan and at Nissan's direction. Okay. Ford and the other cases make the point that a unilateral action, one that is directed by someone else, is not a contact. And so...
What about, does Adient have...
Didn't they agree to do that?
I think they agreed to do that. I agree with you. They
And to
agreed
indemnify?
right.
And then, do you have does ADN have contracts with North Carolina businesses for subcomponents?
It buys components here, but this is again the reason that I would suggest that Bartlett is on all fours with this case. In that case, the engines manufactured in a foreign jurisdiction, may have been Germany, may have been Tennessee, it doesn't matter for our purposes, was sold to the ultimate manufacturer of the finished product, the helicopter, which was then sold into the stream of commerce. Now, I'm not going to get into whether the Eurocopter Airbus was there, but just look at the engine manufacturer, the component manufacturer. Its relationship was entirely in a foreign jurisdiction. Its choice about where that ultimate product was sold was not its, it was the ultimate manufacturer.
Wasn't it a little more attenuated than what we have here?
Not really, Your Honor. In fact, the engine manufacturer in Bartlett purchased components from Monroe, North Carolina, manufacturers in Monroe, North Carolina. Airbus, which was also AHD in that case, was also found to not have jurisdiction, even though it provided service and technical manuals available on a website for buyers of those helicopters to use, and responded to technical inquiries that came from the ultimate owner, in that case Duke Hospital, through the distributor back to Airbus Deutschland, Airbus Germany, and Airbus Germany responded pursuant to the terms of its distributor agreement. So there's really parallels to everything that Adient says is a contact with North Carolina in Bartlett. If you go down that list and you analyze it with, it's got to be Adient's contact with North Carolina. It can't be the unilateral or random or fortuitous or attenuated contact of someone else. And Adient has to be reaching out from the jurisdiction in which it was in order to make the contact, in order to purposely avail itself of our jurisdiction and its laws.
Did Adient send salespeople to North Carolina? Or
It did, Your Honor, but there's nothing in the record, and plaintiffs decided not to depose anyone in this case. So they only put in a large volume of documents that they found in discovery unauthenticated. So there were trips by Adient salespeople. We don't really know much about the purpose.
So you're saying there's nothing in the record evidencing?
I think that they visited Volvo, and that there were some that visited their North Carolina State University to recruit.
Okay.
I think there may have been one visit to Bob King dealerships, but
Right.
the purpose of those visits is not in the record.
I'm interested in hearing what you think about the Harris Teeter case.
I'm glad you asked that, Your Honor, and switching to the issue of consent. As you noted, our statutes are very different than the one in Mallory and Pennsylvania Fire, in that they do not explicitly state registration is consent to jurisdiction. I'm getting to Harris Teeter, but there's a case that Harris Teeter misses, and Espin, also Judge Boyle's case, misses. And it's also Judge Holmes' case. It came 4 years after Pennsylvania Fire. It's Robert Mitchell Furniture. That case involved Ohio's statute. And the plaintiff's claim in that case was that Ohio, by registering to do business in Ohio, the defendant had consented to jurisdiction there. Judge Holmes said no. Judge Holmes said the statute either needs to say, to be clear, that by registering you're consenting to jurisdiction, or that needs to be known through the case law and the interpretation. That is not the case in North Carolina, and that's what Harris Teeter misses. Harris Teeter misses Robert Mitchell Furniture. Espin misses Robert Mitchell Furniture. It misses that distinction between a statute that expressly says it's consent to jurisdiction and one that only says you have to register it to do business here and hold it off.
Is there some old case law in North Carolina that says something about?
Babb and Steele. And Babb is a case that deals with service of process. In that case, the court found no jurisdiction. It found that there was no jurisdiction over the defendant because service of process on the Secretary of State was improper under the statute. There's dicta that says under the old version of the long-arm statute and service of process statutes that service of process on an agent registered here when the defendant owned property here too might be sufficient, but that's obviously dicta in Babb. The other case that they cite is Steele. Steele involved a completely transient claim. out-of-state plaintiff suing on an out-of-state plaintiff on a claim arising in D.C. It's a 1934 case. It predates international shooting. And the court in that case says jurisdiction was assumed, acknowledged in that case. The question was whether service on the Secretary of State was sufficient. And again, there's that statement that under the old registration statutes, which are no longer in effect, that registration to do business and or registration of an agent and doing business here is enough for service to be made on the Secretary of State. That's a very different point than jurisdiction, especially when it's conceded. Neither of those cases have a holding that registering to do business here is necessarily consent.
What do you think about the Robinson Treatise? Its statement.
I started my career at that firm. And so I respect what they're saying, but what they're saying is really speculation. It is treatise, it's not case law. Remember, Robert Mitchell Furniture says a local construction or the statute has to be explicit. Russell Robinson saying that it is possible and that consenting to jurisdiction is consenting to, or registering is consenting to jurisdiction, frankly, is not definitive enough.
I don't think he says possible. He says jurisdiction over a foreign corporation is established when it qualifies to transact business within the state.
If he thinks if he thinks that's the case, he was putting out a theory that is not in the case law. And the citations below are to older cases under the older form of the long-arm statute and the older form of the Business Corporation Act.
I mean, from 1800.
Yes, they note that the prior version of the Business Corporation Act especially dealt with jurisdiction over foreign corporations. When the current version of the Business Corporation Act was adopted in the 1980s, those provisions were dropped. Instead, the only thing that's left is the long-arm statute. And the citations in the footnotes note that change. That really is an indication that if there was ever an express consent to jurisdiction in our Business Corporation Act, that it was deleted.
What about the commentary?
The commentary is, the commentary is common to any state that's adopted the ADA model of the Business Corporation Act. So South Carolina is another version of that. It says that a foreign entity that registers to do business, let me make sure I get it up here as opposed to reading it off, is amenable to suit in the state. Well, the Fourth Circuit dealt with that very language and that very comment in the context of South Carolina statute and said that amenable to suit is not the same as general jurisdiction. Amenable to suit may mean that you're only amenable to specific jurisdiction. And so being amenable to suit is not enough. And that's the language from the comment. The other comment is the comment to 55B30, which says that a corporation can be found here. And that's the purpose of having a registered office and registered agent. Plaintiff attaches a lot of meaning to the word found as if it were a specific legal term of art. And I acknowledge that one of the things in Mallory that Judge Gorsuch dealt with was, okay, how do we get from tag jurisdiction in individuals, where they can be found in the state, they can be served with process, and there can be personal jurisdiction on any claim, to how we deal with corporations. But he never said that a corporation can simply be tagged because it's got an agent in the state. He said that there was a consent to jurisdiction, and he said, I'm not going to speculate on other statutes. Right?
And I have
Yes.
repeatedly interrupted you. I asked you about Harris Teeter, and then I haven't let you answer it. I'm sorry.
My problem with well, sorry. Let me get on the tag, and then I'll go back to Harris Teeter. There's no case saying that there is such a thing as tag jurisdiction when it comes to corporations. And if you think about it, that would simply mean that corporations are subject to general jurisdiction anywhere they have any form of presence. They have any employee or agent. They would be able to be tagged. That's not how that works. That's the reason we have a specific jurisdiction analysis when it comes to companies that aren't at home in the form. They aren't either incorporated there or have their principal place of business there. To Harris Teeter, I respect Judge Robinson's approach to this, and there are some similarities in the insurance statutes, but it's a different statute. And he cites BAB, and he cites Steele, which, as I just explained, I think are inopposite. They deal with service of process under old statutes, the extent of the long-arm statute, and a notion that having a registered agent and a piece of property in North Carolina subjects one to jurisdiction for any claim. Now that comes from Steele and it comes prior to international shoe. I don't think it stands up to modern analysis. What he doesn't mention, if I recall correctly, or deal with in full, is the Robert Mitchell furniture distinction. He does not look to whether or not the statute actually has an express consent to jurisdiction in it. Judge Boyle made the same, I would submit, error in his analysis. He did not look at the distinction between Pennsylvania Fire and Robert Mitchell Furniture, or the statute in Mallory, all of which, Mallory and Pennsylvania Fire, it's unquestioned that those had explicit consents to jurisdiction. So I think now, Pancredido, Judge Meyer's case, does analyze that distinction. And while the plaintiff said that the problem with Pancredido is that no one made the argument to Judge Myers, we've gone back in the briefs and looked, and in fact, the parties did argue BAB and Steele to Judge Myers as well. He obviously found them opposite because they didn't make it into his opinion.
Do you think it's significant that the injured person, the Texas resident?
I don't think that it's significant when he was injured here, and so it's a local injury. But I would go back to a number of, I think it's helpful to go back though to the list of potential contacts that they have and that they have listed. That he was a passenger in the car in North Carolina, I think, is relevant only in that the injury was here. But Worldwide Volkswagen would say the mere fact that the product made it here is not enough to assert jurisdiction over the defendant. The seat was sold by Nissan, not Adient, to a North Carolina dealer is not an Adient contact. That Adient registered to do business is first of all a fact that was not present at the time that jurisdiction was acquired, which is when the complaint was filed or the accident occurred. And the Fourth Circuit has long said in Ratliff, when it comes to specific jurisdictions, this is a 1971 Fourth Circuit case cited in our brief, that there's a difference between registering to do business and actually doing business. So registration to do business is not sufficient for the number of contacts analysis. Adient's a first-tier supplier to Nissan, but that all occurs in Tennessee, as we discussed. Adient is a large manufacturer of automotive seats. Granted, but there's nothing to show that Adient has built. Adient doesn't sell standalone seats. It doesn't advertise in North Carolina. It doesn't have a service system here, and you can't take your seat to an Adient store and get it fixed. It does respond to warranty claims most of the time financially by reimbursing Nissan, and we have one evidence of drop shipping one seat to North Carolina. But I would submit that those are still contacts of Nissan's.
Hasn't Adient agreed to indemnify and defend Nissan in lawsuits in North Carolina?
Adient has agreed to defend Nissan in lawsuits. It never said in North Carolina.
In lawsuits anywhere?
In lawsuits anywhere, at Nissan's election. Mm-hmm. And so, as you know, indemnify and defend are different things, and Nissan can pick either one, or both, or neither. So if you go down that list and apply the test that the plaintiff's claim had to arise out of, the other one is that they bought products here. They bought component parts here. Mm-hmm. But that's unrelated to the product that Adient built and sold, right? That's just combining components. Buying products here is very different than selling into.
Buying subcomponents of the seats that they
buying subcomponents, but again, Bartlett says, that same fact is present in Bartlett as well. buying out of North Carolina is very different than selling into North Carolina and creating a market for its product. So if you apply the test, the contact can't be unilateral. It has to be the action of aiding, and it has to show some sort of purpose, some intent and purposefulness availment. Then that test doesn't come on any of those contacts. That's why the court found that none of the contacts relate to the plaintiff's claim. They cite other cases. They cite older ones. They cite Bush and Cox. Bush is a case where a Swedish company sold to a New York distributor that was the exclusive distributor of their washing machines throughout the country in the United States. And the distributor, if I remember correctly, was affiliated with Bush. And Judge Eagles said, well, merely selling through a distributor that you control or as your exclusive distributor is not enough if you are using that to direct and create a market in that foreign state. Thurman versus Honda, which they cite, involved the car manufacturer. It would have involved the equivalent of Nissan, not the component manufacturer. Lorenzo versus Toshiba, the Rhode Island case, the court rested on the notion that Samsung, which built the battery, had been generating and trying to build a market for its own batteries through advertising and sales. And then Wilhelm and Kia, the other two cases which they've most cited recently by memo, are equally in equal categories with that, and frankly do not square with Bartlett and Cohen in Cambridge. So, Your Honor, we think that this is a case where it's very clear that the contacts are not what gives rise to the plaintiff's claim, and that they're not related enough to the plaintiff's claim to serve as jurisdiction. They are also not necessarily, the alleged contacts aren't for the most part Adient's actions, and they are not sufficient to show purposeful availment. As to Bartlett, if I believe I've got it correctly, it may have been AHD or the engine manufacturer, but I believe it was AHD that bought components for the engine from Monroe, North Carolina. So to sum up, Your Honor, we think that there's 2 points here. One, the General Assembly gets the choice as to whether or not to condition registration to do business on consent, general jurisdiction, or jurisdiction on all claims. There's no evidence that that was intended, and there's no way for a party from outside this, or a foreign company outside the state to know that that's what it's consenting to, agreeing to when it registers to do business. There's nothing.
I mean, what's your clearest evidence to the contrary? I mean, what are you relying on to the contrary there?
What would be the contrary to, I'm sorry? They had knowledge?
Had consent, yeah.
I think you would have to say something like in Pennsylvania Fire, where it says that registration is consent to general jurisdiction, or something like the Pennsylvania statute at issue, the Pennsylvania statute in Pennsylvania Fire, or the statute in Mallory, which explicitly said that consenting to jurisdiction or registering to do business would be consent to jurisdiction later.
And then for specific jurisdiction, what would you?
I don't, for specific jurisdiction, it's a minimum contacts analysis, right? I mean, the question for consent is whether they consented to jurisdiction.
Right. But okay, so you've not, so you've
Not
taken care of
consent
that.
way.
Yeah, so,
For specific jurisdiction, we simply do not, we think the court got it right. We think the court found that the limited conduct associated with this case occurred in Tennessee, and that the contacts that plaintiffs have alleged do not serve as sufficient contacts for purposeful availment under the test established in Ford Motor, in which Judge Tyson has done a very good job of synthesizing our cases in Bartlett. And if you apply those 2 cases and the principles on which they rely, there is no jurisdiction here in the court. There's no further questions.
thank you.
Thank you.
How much time do you think?
7 minutes.
7.
May it please the court, I will try to be as quick as I can. We agree that the contacts of the issue have to be Adient's contacts. Of course they do. I mean, that's not a dispute. Adient purposely availed itself of North Carolina here primarily because it entered into a contract for which it was the exclusive supplier of seats for the Nissan Altimas. And so if you listen to all these arguments, they really boil down to a claim, basically, that they were just unaware of the fact that Nissan Altimas were being sold in North Carolina. They never actually say that, of course, because they know that it actually sounds crazy. What's interesting is that in the Thurman case, directly on point with Honda, the defendant never actually did make that argument. The same thing, seat manufacturer. And here's what the court said. Despite TS Tech's claim, that's the seatbelt manufacturer, that it had no actual knowledge that one of its distributors, meaning Honda, sold products in the form state, such ignorance defies reason and can aptly be labeled as willful. And I mean, that would be the situation here. Adient agrees to be an exclusive supplier. It knows where these cars are going. Second, it agreed to indemnify Nissan, and by the way, it didn't agree to indemnify Nissan wherever. It said, we will indemnify you where your cars are sold. So that is at least constructive knowledge about that Nissan Altimas were being sold here. I would also note all the things that Adient simply just doesn't address because they can't address it. The Thurman case, the Lorenzen case, the two cases we cited last week, all these cases clearly hold that simply because you use a distributor to get into the state, that doesn't mean you're not subject to jurisdiction here. And Adient, in our opening brief, we pointed out that was Adient's argument. And they doubled down on that in their brief. I mean, they said that. I had the quote in our brief. They said, plaintiff Cameron Vlassis fails because he cannot show that Adient sold directly in North Carolina. That's just not a requirement. So, and I would also note just about the Ford case, they talked about Ford's contacts in Ford. Well, the Supreme Court in Ford referenced how Ford serviced vehicles in the state, but if you read the opinion, it did so through its dealers, right? Ford doesn't service your car, the Ford dealer does. And so what that establishes is that a defendant's distributor's contacts are relevant to you. That's part of the system. And so which is just another way of saying that when Adient enters into this contract to be the exclusive supplier for these seats that it knows are going into North Carolina, the fact that certain service is being done here on those seats where it ships matters. And by the way, we only found one of those examples that we sent, but if you look at our brief, we have a chart. There's tons of examples of them performing parts and service here.
What do you mean by performing parts and service here?
Fair enough. I was not correct there. It is true that the service is performed by the dealerships. What happened is that that Adient is contractually obligated to pay when its parts fail. And so if someone brings a car in and the seat's broken, the dealer will fix it, but then they'll back bill Adient for it. But Adient knows that, and they're paying money for it.
Does Adient send the parts here?
At least one of the examples we had is the drop ship, yes.
Okay.
I don't know how many other examples we have. I don't have it on the tip of my tongue. I apologize, but I do believe it's more than one. There was just a brief mention that, that we didn't, we sort of chose not to depose anyone in this case. I didn't want to get into this on appeal. We did not argue this on appeal, but we did ask to depose them. That was in our brief. We were not allowed to depose. And I hesitate to even mention this because I don't think it's all called for. But the absolute worst result in this case for the plaintiff, I would submit, would be some sort of remand for, I don't know, discovery about whether Adient knew that Altimas were being sold in North Carolina. I don't think you need to do that because I think it's absurd, but that's the issue. I'm happy to answer any further questions about.
Why is it the worst result?
Well, I think that ought to be the worst result for the plaintiff because what I don't think the court ought to do would be simply to affirm. That would be a nightmare for all the reasons I suggested. I also didn't hear any argument about what the effective ruling here for them would be, about the fact that you would have to sue multiple people in multiple courts every time you had a claim. I'm happy to answer any other questions about purposeful abandonment. That obviously has been the thrust of my argument today because I think it's probably the more important of the issues. When it comes to the consent issue, every argument that they raised today, every one of those was addressed in our reply brief. And I don't want to waste your time in going over through it, but the statute here isn't different than the Pennsylvania fire. In fact, courts have noted that there was no mention of jurisdictional effect of that statute for Pennsylvania fire. We addressed the Robert Mitchell case. That court noted that the statute at issue, the wording matters, but so does how courts interpret that statute. They called it the local construction matters. Well, here you have Babb and Steele. Babb, by the way, was not just about service of process. Read the opinion. It literally talks about jurisdiction. Same with Steele. And to be very clear, BAB is about both service of process and jurisdiction because they're the same thing when you're tagged, right? What creates jurisdiction is the fact that you're served. And that's the same thing that happens here. You know, opposing counsel mentioned, well, there's no such thing as tag jurisdiction for corporations. There is. That literally is exactly what Justice Gorsuch wrote a law review article about in the Mallory opinion. The point is that you can tag corporations, but not, as he said, anywhere. You can tag them where they must be found. And so if a state chooses to require you to register to do business, then you can be tagged and you can be found. You mentioned the opposing counsel mentioned the footnote of Robinson about the change to the Model Business Corporation Act. That's true, but as the footnote says, the reason that the Model Business Corporation Act removed the jurisdictional statute is because Chapter 75 had been enacted, didn't exist before that. So the Business Corporation Act is in the 50s, and there's no general jurisdictional statute, so the Act has a statute. Then we enact Chapter 75, which has the jurisdictional statute, and so when they update the Model Business Act, they just remove the provision about jurisdiction. And what Robinson says is, well, clearly that wasn't meant to change anything about the substance of the jurisdiction. And the substance that had been previously mentioned very clearly was, if you register to do business, you are subject to jurisdiction here. Finally, we noted in our brief that tons of other states provide for this jurisdiction. This is not an uncommon thing, it's not a weird thing. I'm happy to answer any other questions. Otherwise, I ask the court to reverse on either grounds. I think that as I mentioned, the specific jurisdiction is probably the clearer, but I think that my client should win on either ground.
Any further questions? Thank you very much. I want to thank both of you for your excellent arguments today.